Hello and welcome to this presentation on the new subject access code. This is the third talk in this series. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. In this talk I want to talk about some of the things you can get if you're applying for access to data, and also what you have to give if you're the controller. By Section 8 of the Data Protection Act, what the person making the request is entitled to is a copy of the information in permanent form, unless the supply of that copy isn't possible or would involve disproportionate effort, and I'm going to say a bit about disproportionate effort in a moment, or if the data subject agrees otherwise. Also, if the information, which is the personal data, of which the requester is the data subject, if that's expressed in terms which aren't intelligible without explanation, the copy must be accompanied by an explanation of those terms. So any code needs to be unpacked, in other words. Let's have a look at what's meant by disproportionate effort. The code says that there is only limited scope for assessing whether complying with a request by supplying a copy of the requested information in permanent form would result in so much work or expense as to outweigh the requester's right of access to their personal data. So the code says that disproportionate effort will only apply in the most exceptional of cases. And even then, the controller must still comply with the request in some other way. For example, allowing the requestor to have a view of the original documents. It also doesn't negate the other data protection rights that the requestor has. So these are to be told, to be given descriptions of the personal data, told what the processing purpose is, and either the recipients or classes of recipients. The second item under Section 8 of the DPA is the need to explain the information supplied. And the code says that the information should be capable of being understood by the average person, and it doesn't require the controller to ensure that the information is provided in a form that is intelligible to the particular individual making the request. Now, as a general rule, that must be right, but it must be read subject to the requirements on the controller under the Equality Act 2010 in the case of a person with disabilities. The controller will have a duty to make reasonable adjustments for persons with disabilities. The code doesn't mention this, but it's clearly a duty that will fall on the controller. The requirement then to explain the information supplied will require the controller to explain the codes which are used in the data. Now, what does the controller do when confronted by repetitive Section 7 requests? Well, the controller doesn't have to comply with repetitive requests by the same individual in certain circumstances, and those circumstances are if the controller has previously complied with a Section 7 request and the repeat request is identical or similar. That, however, is subject to this point, that if a reasonable interval has elapsed from compliance with the original request to the making of the current request, then the controller may still be under the duty to respond to the request. How do you determine what is a reasonable interval? Well, you have regard to the nature of the data, the purposes for which it's being processed, and the frequency with which it's being altered. And page 38 in the code gives some examples of this. The Section 7 request made to a credit reference agency can be limited to personal data which is relevant to the requestor's financial standing, and it'll be taken to be limited in that way unless the request shows a contrary intention. The credit reference agency must give the statement of the requestor's rights under Section 159 of the Consumer Credit Act 1974. So, if the requestor considers that an entry in their file is incorrect, and that if it's not corrected it's likely to prejudice them, then the requestor may give notice to the agency requiring it either to remove the entry from the file or to amend it, and the agencies have to give notice of these rights. I want to turn next to unstructured personal data, which is personal data other than information which is recorded as part of, or with the intention that it should form part of, any set of information relating to individuals, to the extent that the set is structured by reference to individuals or by reference to criteria relating to individuals, and which is not data falling under the following headings. So it's not being processed by means of equipment operating automatically in response to instructions given for that purpose. So it's not automated decision making. It's not recorded with the intention that it should be processed by means of such automatic equipment. And it's not recorded as part of a relevant filing system or with the intention that it should form part of a relevant filing system. And then finally, it must not be other personal data which forms part of an accessible record. A public authority has no obligation in relation to any unstructured personal data to respond to a subject access request unless the Section 7 request contains a description of the data. And secondly, the authority does not estimate that the cost of complying with the request, so far as it relates to those data, would exceed the appropriate limit that's been set. The public authority still has the obligation to inform the data subject whether personal data is being processed by or on behalf of the data controller public authority, and that duty applies in relation to the unstructured personal data unless the estimated cost of complying with that obligation alone in relation to the data would exceed the regulation prescribed limit. There are different amounts prescribed in relation to different cases. And when estimating how much the cost would be, the public authority has to make that estimate in accordance with the regulations made under Section 12 of the Freedom of Information Act 2000. The code itself is issued under Section 51 of the DPA as part of the Commissioner's duty to promote good practice. So it's important to remember that it's non-binding and it is not an evidential code. So compare this code to the Equality and Human Rights Commission's statutory code. The latter can be cited in court cases and must be taken into account so far as is relevant. This code is not evidential in that way. Section 51 does not give it that status. So it's a non-binding code, and it states that it's the Information Commissioner's interpretation of what the Data Protection Act requires, of organisations in order for them to comply. So, it's important to take into account to ensure compliance for Information Commissioner purposes, but the Information Commissioner can't take enforcement action over a failure to adopt good practice or to act on the Code's recommendations unless the matter which the Commissioner decides to intervene on itself is a breach of the Data Protection Act. Now, naturally, the Commissioner will operate on the basis of their interpretation of the Data Protection Act. So, in terms of considering making a complaint to the Commissioner or ensuring that as a controller you are able to resist any investigation by the Commissioner, then it's very well worthwhile keeping the good practice that the Code sets. So the data controller can avoid complaints by following the Code's good practice points, and will also be able to demonstrate that they have done so because of the evidential aspects of the Code. And for example, the Code gives indicators of good practice at various points. But generally speaking, these are training on data protection given to staff and those who are going to have to process data, the existence of guidance links on the intranet, having specific staff to handle subject access requests, in large organisations having an information champion who actively promotes good practice, and then finally the monitoring of compliance within the organisation. Chapter 8 of the Code in particular deals with what information must be supplied, the concept of decision making, the form in which information must be supplied, and explaining the information supplied. And I've taken you through some of that earlier on. There are a list of exemptions which the Code deals with, and some of these are fairly obvious, I'd suggest. Confidential references are exempt from subject access requests. Publicly available information is exempt. Information relating to crime and taxation, management information, or personal data relating to negotiations with the person making the request. Personal data relating to regulatory activity is exempt, as is legal advice and proceedings, social work records, and health and education records. There are special rules that apply to credit files, health records, information held by schools about pupils, and information about examinations. And these are dealt with in Chapter 10 of the Code at page 48. Finally, I'd like to say something about the enforcement of the Act, which is dealt with in Chapter 11 of the Code at page 53 and following. The Information Commissioner can order compliance with the Act after conducting an assessment, but can't award compensation to individuals. The Commissioner can serve an enforcement notice which has got a criminal sanction if the controller defaults on it. On the other hand, a court can award compensation for breaches of the Act, including damages for distress. And it's worth noting that the controller will have a defence if the controller has taken all reasonable steps to avoid breach of the Act, and a court would regard the steps set out in the Code as some of the reasonable steps that generically ought to be taken by a controller. But of course, what will constitute a reasonable step for a particular data controller to take will depend very much on the facts of that case. I hope that you've found the presentations on the new code useful. If you have a look at the first presentation, you'll see the link to the text of the code itself. Thank you very much.